Major breaking news. The United States Court of Appeals for the Fifth Circuit out of Louisiana and Texas has found that federal gun control law 18 U.S.C. 922 G3 as applied to non-violent marijuana users is unconstitutional in an as-applied challenge. Let's break this down and what it means for your rights when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed. What the 10/7 attacks on Israel teach we Americans about the right to bear arms. We must always be learning from the mistakes throughout history and across the world so we never lose our fundamental individual rights, including our right to keep and bear arms. As a side note, you probably are seeing me a lot on Fox News recently. I'm going to try to find a way to post all the links of my appearances in some readily accessible place. I'm working on that right now, but I know a lot of you see me on TV there, but I'll try to find a way to post it so people that aren't at home watching the television can see me by virtue of those links. I'll work on that soon. All right, folks, so major breaking news. The United States Court of Appeals out of the Fifth Circuit. You may recall the Fifth Circuit. They're a very good gun jurisdiction, frankly, very good on the Second Amendment. They found with a powerful three-judge panel of very intelligent judges down there in the Fifth Circuit, 3-0, found that the federal gun control law, 18 U.S.C. 922 G3, which is within that list of what are known as prohibited people that are not allowed to possess firearms. That's the list 922G. 922G3 says that if you are a user of an illegal substance, then you may not possess firearms. This was a challenge, both the facial and an as-applied challenge. Just to jog your memory, a facial challenge to a gun control law says that under no set of circumstances ever can the statute or the gun control law be constitutional. And then an as-applied challenge says that maybe that gun control law can be constitutional in certain applications, but it's not constitutional as applied to me. Well, Paulo Connolly brought this challenge to a criminal indictment where she was indicted for possessing firearms while being a non-violent user of marijuana. In her criminal defense, she said that the law facially is unconstitutional and 922G3 as applied to her specifically is unconstitutional. Now, the Fifth Circuit said, after reviewing the record, which we'll get to in 1 second, they said that the government had done enough historically to show that you could ban people from having firearms if they are mentally impaired at the time they possess the gun. They talked about various laws that dealt with people that were impaired mentally just because they were mentally ill. At the time, I think they were called lunatics, by the way. Lunatics was the word at the time of the founding. They described people that are violently mentally ill. And if you were a lunatic out of your mind, you could, in theory, be imprisoned or locked up in some way for your own safety or the safety of others. They did discuss that in this case. Paulo Connolly, the United States versus Paulo Connolly is the name of the case out of the Fifth Circuit we're talking about today. And they also went on to say that there is some discussion by a founding father named Dr. Benjamin Rush. Dr. Benjamin Rush, I think he was from Pennsylvania, where he discussed that when you are drunk from alcohol, you are essentially mentally impaired. You are effectively a lunatic in the sense that you're not capable of understanding what you're doing. That was a discussion at the time of the founding by one of our founding fathers, Dr. Benjamin Rush. I think he actually signed the Declaration of Independence, if I remember correctly, about Dr. Rush. Anyway, in light of that history, what the Fifth Circuit said is there may be certain circumstances where federal gun control law 18 U.S.C. 922 G3 could conceivably be constitutional as applied to someone out there in some case down the road. So as a facial matter, the Fifth Circuit said we cannot say facially in all instances this federal gun control law is unconstitutional under the Second Amendment, which is kind of what I would always expect. I don't think that's a big controversy that could conceivably be true based on the historical record. But now let's go to where the real fight is, which is Paolo Connolly's as applied challenge to her, because she's like, look, I don't know the story with other people, but with me, I'm nonviolent. I have no criminal record. I've never done anything to hurt a fly. I occasionally use pot to sleep. That's essentially what she said. And there were guns in the home when it was searched for reasons we don't need to get into for the purpose of this video. So anyway, so she was found to have possessing guns and pot and admitted to using pot on occasion to help her sleep at night. So the question is this constitutional as applied to Paolo Connolly? Well, the Fifth Circuit did the analysis properly in that they started with the text of the Second Amendment. The text of the Second Amendment as defined by the U.S. Supreme Court in, for example, Heller. And the one issue that came up was, is Paolo Connolly part of the people, as in the right of the people to keep and bear arms shall not be infringed? Well, because Paolo Connolly is an American citizen, there's no dispute that she's part of the people. In fact, the Fifth Circuit did a very nice job laying this out. It should not be controversial at this point, but it goes on to say that obviously because Ms. Connolly is a member of the American community, she's part of our national political community and an American citizen, she's clearly part of the people. And because Federal Gun Control Law 922G3 is restricting her ability to keep, which means to possess, to have, and to bear, which means to carry, obviously the text is being implicated here by virtue of this gun control law as applied to Ms. Connolly that says you can't have a gun, which obviously textually is an infringement textually on the right to keep and bear arms. So then, of course, we know what happens. Although I will tell you this, I'm going to digress just very briefly. There are many federal judges that are totally incompetent on this topic. And when I say to you, if you follow my channel, I will make you better on the Second Amendment, smarter on the Second Amendment, and a better lawyer effectively than even federal judges on the Second Amendment. I mean it, because I'm telling you, I see what's out there. And if you follow this channel and you do the things that we talk about on this channel, you will actually be better than federal judges and a lot of lawyers. Okay, we're going to talk about that in a separate video later on with some other mistakes I'm seeing. But the good news is when it comes to the Paolo Connolly case out of the Fifth Circuit got it right. And I urge you to take a look at this opinion to see how Second Amendment analysis is done properly by legitimate federal judges that know what they're doing. So again, as a matter of text, the text is implicated. And you know what that means? The burden shifts to the government to do what? The government has the burden at that point to demonstrate there is some long-standing historical tradition in American life of restricting the right to keep and bear arms in some particular way. The example I like to give historically is that obviously you have the right to keep and bear arms, but you don't have the right to keep and bear arms to commit cold-blooded murder. The reason why we know that is not from the text, it's from at the time of the founding, you could not use a gun to commit cold-blooded murder. So obviously the Second Amendment right can be honored without allowing people to assert a Second Amendment defense to engaging in cold-blooded murder. That's not part of our historical tradition to allow people to engage in cold-blooded murder, despite the fact we have a Second Amendment. So the question is, could the government, in this case, dealing with 922G3 marijuana users, come up with historical analog laws going back to the founding that would somehow justify this as applied to the nonviolent Miss Connolly? And the Fifth Circuit says, no, they couldn't do it. There's three buckets of laws that the government proffered, that the Merrick Garland Department of Justice proffered to try to justify the 922G3 law as applied to Miss Connolly. They first said that at the time of the founding you had mentally ill laws. They could put mentally ill people away. The second bucket the government proffered was that they could disarm dangerous people. And the third was intoxication laws. So basically the Fifth Circuit analyzed all three buckets of these: the mentally ill restriction laws at the time of the founding, laws involving dangerous individuals at the time of the founding, and intoxication laws. To begin with, mentally ill, what the Fifth Circuit said is there are simply no laws on the books at the time of the founding that restricted your ability to keep and bear arms if you were mentally ill. The best the government could come up with is they could lock you up if you were mentally ill and a danger to yourself, but that had nothing to do with restricting of firearms. So that's the first thing they said, that's just not enough. Then they talked about dangerous individuals. And then they looked at the specific laws cited by the government, and the dangerous individual laws cited by the Department of Justice here were dealing really with laws that forbid Catholics from having guns, which obviously is unconstitutional today. And as Justice Brett Kavanaugh explained in Rahimi, those kinds of laws have been left behind by American history. So we don't use those laws that are racist or anti-religion or whatever anymore. They're considered noxious and not considered for the purposes of drawing historical traditional laws as to what can and cannot be done with our constitutional rights. So the laws that restricted Catholics from having guns, not analogous. Furthermore, the Department of Justice then tried to talk about loyalty oaths, saying that at the time of the American Revolutionary War, British people or Americans that would refuse to swear an oath at the Patriot cause could be disarmed. But the Fifth Circuit says that's really a wartime measure, and that was speaking to people that were really outside of the national polity, if you think about it. If you're within the national polity, meaning you were an American citizen in America, when could you be disarmed? That's the proper question. Not can you disarm people that our country was at war with, whether it be today ISIS or Al-Qaeda, and back at the time of the founding, it would be the British, the Tories, the Tory militias, maybe some of the Indian tribes. These were people that were in warlike conditions, and what the Fifth Circuit basically said is the proper analogy is when can you disarm an American citizen as America, not when can you deny guns to people that you're literally fighting a war against. It doesn't make any sense. And of course, the Fifth Circuit analysis does make sense, but why would we talk about, a disarmament law saying you can't armed the Japanese in World War II? How does that tell us anything about American rights? Obviously it doesn't, and that's what the Fifth Circuit said. And the last thing is these intoxication laws. And the intoxication laws are quite interesting, but really at the end of the day, the Fifth Circuit said the thing about the intoxication laws is they're very specific to a moment in time, meaning that to the extent that you are intoxicated, at a moment in time where you're drunk, intoxicated, and not able to touch fingers with your senses, so to speak, you could be disarmed conceivably at that moment in time. But that doesn't speak to what happens if, days later, there's nothing wrong with you, you're totally in a sound mind and perfect normal state of affairs. How does an intoxication law set aside the question as to whether or not it's the right time period for the sake of argument, but set that issue aside? How is it possible that, let's say you were drunk or out of your mind 2 weeks ago, but you're no longer out of your mind today? How would those laws that say you can't drink and shoot guns and stuff like that in the middle of the night, how does that apply to a person that's of sound mind in a particular day? And the Fifth Circuit said that's not true. Then they went on to say that to the extent the government ain't been proper to allow these laws, the laws technically speaking said that if you were drunk, you couldn't shoot guns. They said nothing about if you were drunk, you could not possess guns. So the Fifth Circuit also made that distinction between being drunk and not being allowed to shoot guns versus being drunk and not being allowed to have guns. It's a fine distinction the Fifth Circuit made. And again, with all of this stuff, they said the Department of Justice has simply not come forth with enough evidence to show a historical tradition that would ban a nonviolent occasional user of a substance such as marijuana from being able to possess firearms for long periods of time. And as a consequence, they found 18 U.S.C. 922 G3 constitutional facially, but they said that as applied to the defendant here in this criminal case, Paolo Connolly, it's not constitutional under the Second Amendment as applied to her, and thus the indictment should go away on those grounds. So what's going to happen next, and what do I think about this? I'm actually not super happy with this decision, and this is why you turn to my channel versus some others, because I'm going to give you the sort of the strategic professional thought I have. On the one hand, the Fifth Circuit got it right, and I like that. That's good, okay? But from a big picture point of view, I don't love this decision. Why is that? Remember when I told you, I talked about this at the Gun Owners of America conference in Knoxville a couple weeks ago. I had a great time, by the way, a great event. But I also have said this on the channel, that is the Second Amendment movement, we want to be strategic about which cases go to the U.S. Supreme Court, because this U.S. Supreme Court is only taking 70 to 75 cases a year for all of American law. That's all American laws. federal statutes, state issues, constitutional laws, blah, 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 tons of stuff. So the most we can hope to get up there in any given term, in my opinion, is 2 to 3 Second Amendment related cases, which within that bucket of Second Amendment related cases includes challenges to ATF laws like the frame or receiver rule or bump stocks. So you're only got a couple shots every year to get before the U.S. Supreme Court. And what I'm not super happy about with this Connolly case is because they're saying that this federal statute as applied to Ms. Connolly is not constitutional. I could see the Merrick Garland, Joe Biden, Kamala Harris, Department of Justice trying to rush this case to the Supreme Court like they did with Rahimi. And next thing you know, we're going to be spending the next 12 months in the Second Amendment movement dealing with not just the frame or receiver rule in the Vanderstock case, which is fine and a good thing to knock out, but instead of the Supreme Court hearing other Second Amendment related cases, they may want to take this case dealing with pot users and firearms, which is not, frankly, a huge deal in the Second Amendment community. I would much prefer winning some other cases first with sympathetic plaintiffs like 18 to 20-year-olds, or obviously quote-unquote assault weapon ban case out of Maryland. These other cases I think are more important for our movement, and also it's a lot easier for our side, the movement, to win before the Supreme Court if you have sympathetic parties advocating for Second Amendment rights. But when you have people that have been arrested and are criminal defendants in kind of bad circumstances, and they use illegal drugs and stuff like this, because marijuana is still it's a controlled substance under federal law. I understand the disconnect with some states, but the reality is it's still a federal law that you can't use marijuana and blah, blah, blah. You know what I'm saying? It's a legal drug. So it's not the most sympathetic set of facts or sympathetic people that we want going before the Supreme Court in this particular case. So again, my druthers is always to have a sympathetic pro-Second Amendment person or group in front of the Supreme Court rather than someone that's a little dicey. And I don't know anything about Paolo Connolly other than from what's on this record. But I mean, the fact that, she got arrested in the context of her husband, I think, getting arrested, and there was other sort of shenanigans going on where there's a lot of drug paraphernalia in the home. And I think she acknowledged that the family had done cocaine. I don't think she had done it, but I think her husband may have been involved with cocaine or crack or something like that. But whatever it is, the point is that sort of the context of this case is not as clean and smooth and favorable and innocent as I would like in a perfect situation. So I don't particularly love the fact that Fifth Circuit did this, because it's going to increase the odds of this case being taken by the U.S. Supreme Court for the next term. And if they take this Second Amendment case, it means it's bumping out of the line other much more favorable Second Amendment cases where we can get favorable rulings. So anyway, there you have it, folks. We will certainly cover what happens next. I suspect we'll see a cert request at some point by Merrick Garland. And then if the Trump people take over the Department of Justice, it'll be interesting to see what happens there, but we won't know that for a few months. Okay, folks, make sure you follow me on X at 4Boxes Diner. I will find a way to put a link to all my Fox News appearances up at some point soon. For the moment, I'll just try to put them in the community notes. And again, don't forget to follow me at X at 4Boxes Diner. Make sure you subscribe and like this video, and we will see you again very soon, I hope, here at the 4Boxes Diner.
Orders up. Table 2A.